All right, we've got this breaking news just coming into our newsroom right now.
Gun rights are at the forefront of discussion today as the U.S. Supreme Court issues a major ruling.
How do courts determine whether or not the use of force is objectively reasonable?
This is something that actually comes from common law England. The king is sovereign, and the government has to waive that sovereign immunity.
That seems like guilty until proven innocent. That's not within the lawful jurisdiction of a government.
The Supreme Court just did something that hasn't happened in years. All 9 justices, every single one of them, agreed on a decision that's about to change how your constitutional rights work in every state across America. When justices who normally can't agree on anything suddenly speak with one voice, something extraordinary is happening. This isn't just another court case. This ruling affects what happens when you encounter law enforcement, how your rights are protected, and whether justice depends on where you live. For years, Americans in different states had different levels of constitutional protection for the exact same situation. That's all about to change. Before this ruling came down, the country was split into a patchwork of conflicting legal standards. Federal courts couldn't agree on one of the most fundamental questions in constitutional law. The result was chaos. Your rights literally changed depending on which side of a state border you stood on. Let me explain how bad this had gotten. In Texas, Louisiana, and Mississippi, federal judges were using one set of rules. Travel west to California, Oregon, or Washington, and suddenly the courts applied completely different standards. Head up to the Northeast and you'd find yet another interpretation of the same constitutional provision. The numbers tell a shocking story. Between 2018 and 2023, federal appeals courts published over 240 decisions on this specific constitutional issue. They disagreed with each other in about 60% of those cases. Think about that for a second. More than half the time, judges looking at the same constitution, the same amendments, the same legal precedents, reached opposite conclusions. This created an absurd situation where lawyers had to tell their clients that their chances of winning depended less on the facts of their case and more on which courthouse they walked into. The federal government itself was taking different legal positions in different courts because it knew each circuit had its own rules. Justice wasn't blind anymore. It had become a geographic lottery. The case that finally forced the Supreme Court to act started with an ordinary encounter that spiraled into a constitutional crisis. An individual was going about their daily routine when they crossed paths with law enforcement. Nothing about the initial moments suggested this would become a landmark Supreme Court case. The interaction began routinely. No weapons were visible, no crimes were in progress, no immediate danger existed, but within seconds, the situation changed dramatically. The individual decided to leave the scene, a decision that triggered a rapid escalation. What happened next would echo through courtrooms across America for years to come. The officer made a split-second choice to use force. That force had permanent, life-altering consequences. The entire incident, from first contact to final outcome, lasted less than 30 seconds. Half a minute that would reshape constitutional law for 330 million Americans. When the family filed a federal lawsuit, they argued the force used was excessive and violated constitutional rights. But the lower court's response revealed the deep flaw in how some judges were analyzing these cases. The court applied something called the moment of threat rule, and this rule was destroying the very concept of accountability. Here's how this rule worked and why it was so dangerous. Courts using this approach would only examine the exact instant when force was used. Everything else was thrown out as irrelevant. The officer's decisions leading up to that moment didn't count. Opportunities to de-escalate were ignored. Poor tactical choices that created danger were dismissed. This approach led to absurd results. In one case, an officer's reckless decisions created a dangerous situation, but because there was a perceived threat at the final second, the court said the force was justified. In another case, an officer had multiple chances to use less aggressive tactics but chose not to. The court said those earlier choices didn't matter for the constitutional analysis. Legal scholars were sounding alarm bells. Professor Seth Stoughton from the University of South Carolina published research showing this rule contradicted everything we know about proper police training. Officers are taught to think tactically, to consider their positioning, to create time and distance when possible. But this legal rule said none of that mattered. The fundamental question was simple but profound. Should someone who makes unreasonable choices that create danger be allowed to claim their response to that self-created danger was reasonable? The Fifth Circuit said yes. Most other courts said no. Someone had to settle this once and for all. Getting the Supreme Court's attention isn't easy. They receive over 7,000 requests every year and take fewer than 100 cases. That's roughly a 1.4% acceptance rate. But this case had something that makes the justices take notice, a clear circuit split that was creating constitutional chaos. The petition to the Supreme Court laid out the problem starkly. The Fifth Circuit's moment of threat rule conflicted with how the 2nd, 3rd, 4th, 6th, 9th, 10th, and 11th Circuits analyzed these cases. All those other courts used what's called a totality of circumstances approach, examining the entire sequence of events, not just the final second. The Supreme Court granted review in June, signaling they were ready to resolve this split. Both sides filed extensive briefs. Organizations from across the political spectrum weighed in. Everyone expected a divided court, maybe a 5-4 or 6-3 decision. Nobody predicted what actually happened. When the decision came down, the first shock was the vote count, 9-0. In today's polarized environment, unanimous Supreme Court decisions on controversial issues are increasingly rare. During the previous term, only about 29% of cases were decided unanimously. On a case involving police use of force and constitutional rights, unanimity was almost unheard of. Justice Sonia Sotomayor wrote the opinion, and her analysis was devastating to the moment of threat rule. She started with the text and history of the Fourth Amendment, which protects against unreasonable searches and seizures. The framers of the Constitution understood reasonableness as a contextual inquiry. You can't determine if something is reasonable by looking at just one isolated moment. The historical evidence was overwhelming. When the Fourth Amendment was written, legal scholars and courts always considered context and circumstances. The idea of freezing time and examining just 1 second would have been alien to the founding generation. The Fifth Circuit had ignored centuries of legal understanding. The court then examined its own precedents. Case after case, going back decades, emphasized that Fourth Amendment analysis requires examining all relevant circumstances. Tennessee v. Garner from 1985, Graham v. Connor from 1989, multiple other decisions all saying the same thing: context matters. But the most powerful part of the opinion was its practical analysis. Justice Sotomayor explained that the moment of threat rule doesn't just fail as constitutional law, it fails as a matter of common sense and good policing. Officers are trained to think tactically, to assess situations, to make decisions that prevent dangerous confrontations. The moment of threat rule essentially told officers that none of their training mattered for legal purposes. The immediate impact started rippling through the federal court system within hours. Hundreds of pending cases involving similar issues suddenly needed reconsideration. In the Fifth Circuit alone, researchers identified at least 47 active cases directly affected by this ruling. These cases were families sued claiming excessive force, and courts applied the now rejected standard would get a second look. Every one of these cases must now be reanalyzed using the correct legal standard. Courts that previously dismissed cases because they only looked at the final second must now examine the full sequence of events. Tactical decisions matter. De-escalation opportunities matter. The choices that create or prevent dangerous situations matter. Law enforcement agencies across the country are scrambling to update their policies and training. The Supreme Court has made clear that officers can be held accountable not just for the final moment when force is used, but for the decisions leading up to that moment. Departments that already emphasize de-escalation and tactical thinking find their approach validated. Those that focused only on split-second decision-making must fundamentally rethink their training. What makes this decision even more remarkable is what didn't happen. No dissenting opinions, no concurrences arguing for a different rationale, not even a separate opinion agreeing with the result but questioning the reasoning. All 9 justices from across the ideological spectrum signed onto every word of Justice Sotomayor's opinion. This kind of unanimity sends an unmistakable message. The Fifth Circuit hadn't just gotten the law wrong, they had gotten it so wrong that even the most law enforcement-friendly justices couldn't defend it. When justices who rarely agree on anything speak with one voice, lower courts pay attention. The implications extend far beyond just excessive force cases. The Supreme Court's reasoning about Fourth Amendment reasonableness applies whenever courts evaluate government action. Searches, seizures, stops, arrests, investigatory detentions, all must now be analyzed looking at the totality of circumstances, not just isolated moments. Legal scholars are already exploring whether this reasoning might extend to other constitutional provisions. The Fifth Amendment's Due Process Clause uses similar reasonableness language. The Eighth Amendment's prohibition on cruel and unusual punishment requires contextual analysis. The logic of this decision could reshape constitutional analysis across multiple areas of law. For ordinary citizens, this ruling fundamentally changes how your rights are protected. The Fourth Amendment isn't just legal theory, it governs real interactions with law enforcement. The Supreme Court has now guaranteed that your rights will be evaluated fairly, considering everything that happened, not just a single frozen moment. This represents a major shift toward accountability. Officers now know that courts will examine their tactical decisions, their choices to escalate or de-escalate, their adherence to training and best practices. This could save lives by incentivizing better decision-making and rewarding officers who use smart tactics to avoid dangerous confrontations. The question now becomes implementation. Lower courts must apply this standard consistently. Police departments must update training. Officers must internalize that their entire course of conduct matters, not just the final second. The Supreme Court has spoken unanimously, but real change requires everyone in the system to follow through. Will this actually change outcomes in cases? Will officers adjust their behavior knowing courts will scrutinize their tactical decisions? Will departments invest in better training now that poor tactics can lead to legal liability? The Supreme Court has given us the framework. What happens next depends on how seriously everyone takes this unanimous message. The fact that all 9 justices agreed on this fundamental question of constitutional law shows that some principles transcend political ideology. The idea that context matters, that rights should be evaluated fairly, that geographic location shouldn't determine the level of constitutional protection. These are principles that unite rather than divide. This decision reminds us that despite all the polarization and disagreement, there are still foundational concepts of justice that bring Americans together. When the Supreme Court speaks with one voice on a question this important, it reaffirms that we remain one nation under one constitution, with rights that belong equally to all citizens regardless of where they live. That's it for today, folks. See you in the next video.